Kenyans have watched with horror what happened at Utumishi Academy. The videos from the CCTV are appalling. It is nerve-wracking. What is the law about this matter? You can see Court Helicopter has gotten this clip from other media houses, courtesy of the media houses. Watch. Several questions arise. One, how did the school management decide to put a CCTV camera inside the dormitory of girls? These girls go washing when they're in the dormitory. They can walk naked in the dormitory. Was this CCTV footage installed there illegally? Will the defense team, when they'll be going to court, raise that question that the evidence is illegally acquired as provided for the landmark case that involved the DCJ, Justice Mwilu? The law is that any illegally acquired evidence is not admissible in court of law. That's the first issue. The second issue, these girls appear to have either petrol or kerosene. How did this petrol come in the possession of these girls? Whatever they used, is there a third party? Is there an adult who supplied them with this kerosene? That must either be one, a teacher, two, a watchman, three, a subordinate staff working in that place, fourth, or an outsider. That needs to be investigated. The third issue is the question, were these girls allowed to come to school and their boxes were not checked, and that's why they carried the paraffin or petrol into the dormitory? That is another issue that will be there. But forget about that. Court Helicopter brings you now what is going to happen as from tomorrow. Let us start from the investigation. The law of investigation says that a minor cannot be investigated without the presence of a parent or an advocate. The Minister for Interior, Wakili Kipchumba Murkomen, mentioned that these children who are suspects were mentioned a lot by other students. What does the law say? There must be an identification parade that must be conducted. And that identification parade, those students, the 8, must be identified from that identification parade. 2, the second issue the minister talked about is about confessions. What does the law talk about confessions? Article 50 of the Constitution makes it illegal for any evidence, for any accused person to have what is called self-incriminating evidence. You cannot self-incriminate 2, you cannot be tortured. Were these children beaten? Were they be tortured to give that confession? If they were, that evidence of confession is normally repudiated. It is declined. 3, under the law, when does a confession become valid? Under section 25 and 26 of the Evidence Act, you'll find out that a confession must be done before a judicial officer. If one wants to confess, it must be done in front of a court or a magistrate. 2, if not a magistrate, a police officer above the rank of a chief inspector of police. So a constable, a sergeant, an inspector cannot take a confession. So I hope the law was followed, because we remember, if the police want to assist an accused person to escape, they will allow a junior police officer to take that confession. Once it is taken to court, it is dismissed. Those are the laws that are there. Number 3, the CCTV footage. An electronic certificate must be presented to court showing whether those CCTV footages have been were in good condition, have they ever been serviced, and all those issues. Many cases collapse in court because of shoddy investigation. 2, the chain of command of the exhibits and the evidence that the police have. It must be very, very watertight so that a conviction is going to be found. Any error in investigations, those girls who slaughtered their colleagues in cold blood, they'll be acquitted. A very critical question my crew Vivian has asked: what is the presumption? That is, what is the age for criminal liability? Under the penal code, any child who is below 8 years is not capable of being charged. Any child below 12 years, any child below 12 years, if any of those children is below 12 years, they will not be charged. Criminal liability starts from age 12 and above. That is the law. So if any child among the 8 is below 12 years, they will be taken to a rehabilitation center. They have no criminal liability. Under the penal code, a child below age 12 cannot be charged. Equally, those who are below 14, the state must prove that they understood what they were doing. If they find that they never understood what they were doing, they will not be charged. There is a serious test, and that is why a void dire test, which we dealt with, must be done to ensure that those below 14 understood what they were doing, and they will be charged then as adults. Under section 221 of the Children's Act, the law in section 221 of the Children's Act, as supported by Article 53 of the Constitution, mandates the state to remove children from the criminal justice system through the process called diversion. Will these children be diverted so that they don't face offenses like murder? The state, the Director of Public Prosecution, must come up with that. We have the guidelines, the ODPP guidelines that we have read. Under the ODPP guidelines, they try their level best to divert children from the criminal justice system. in compliance with Article 53, 1, that the best interest of the minor is paramount. 3, they also recommend a rehabilitative approach towards children in conflict with the law. When you talk about these children, very many people will be calling them accused persons. They will be calling them convicts. They will be calling them criminal terms. Under the law, these are children in conflict with the law. They are not criminals. A criminal has to have what is called a criminal mind. In law, it is called a mens rea. The mens rea is the malice aforethought. Do children have a mens rea? It is debatable. Jurisprudence worldwide talks that the children have no capacity to develop a mens rea. If they have no capacity to develop a mens rea, then they cannot be charged with the offense of murder because they lack malice aforethought, they lack what we call a premeditated approach. 2, what can the children be charged with? Somebody has died. The second element of a crime is what is called actus reus. Actus reus is the act that somebody died out of it, and a postmortem has been done. Somebody died. That one, most of the ODPP prefer what they call a manslaughter, and these children avoid the murder trial. But those are arguments the advocates are going to raise, and this is going to be a serious legal battle of whether the law allows. Most judges have used Section 191 of the Children's Act to convict the children because the law does not allow these children to be convicted. Just let me read what the law talks about children in conflict with the law. Section 199 was under the old Children's Act. Today, we have an amended and a new Children's Act. In Section 239, it provides the options recommended for dealing with children in conflict with the law as follows. 1, where a child is tried for an offense and the court is satisfied as to their guilt, the court may deal with the case in one or more of the following ways. A, discharge the child under Section 35(1) of the Penal Code. 2, discharge the child on his or her entering into a recognizance with or without sureties. C, make a probation order against the offender under the provisions of the Probation of Offenders Act. D, commit the offender to the care of a fit person, whether a relative or not, or a charitable children's institution willing to undertake the care of the offender. E, if the child is between 12 years and 15 years of age, order that the child be sent to a rehabilitation institution suitable to the child's needs and circumstances. F, order the child to pay a fine, compensation, or costs, or any of them having regard to the means of the child's parents or guardian. G, in case of a child who has attained the age of 16 years, deal with the child in accordance with the Postal Institutions Act. H, place the child under the care of a qualified counselor or psychologist. I, order that the child be placed in an educational institution or a vocational training program. J, order that the child be placed in a probation hostel under the provisions of the Probation of Offenders Act. K, make a community service order. I, make a restorative justice order. M, make a supervision order. N, make any other orders of diversion provided for in the parts. O, deal with the child in other lawful manner as may be provided under any written law. So the law does not envisage imprisonment of these children. But the final part which most of the judges have relied to, is to deal with the child in any other lawful manner as may be provided under written law. And that is the provision where the judge, Justice Wananda John, in 10 used to jail VKY alias P to 8 years. That is the same provision Justice Professor Joel Ngugi used in petition number 3 to jail a minor for 12 years for the offense of robbery with violence. We are yet to see the jurisprudence of this matter. Parliament must come up and make a law that deals with this question. There is a serious legal lacuna on how this will be. If the kids get serious children-based lawyers, they will give the state the biggest hell to prosecute and convict. All the best. We pass still our condolences to those who lost their minors.